You know, whenever you walk through the heavy double doors of a modern courthouse, the environment just immediately broadcasts this very specific message about power.
Oh, absolutely. It's totally by design.
Right, like you see the polished marble floors, the towering mahogany bench, the judge draped in the black robe, the flags flanking the wall. And the entire architectural setup is basically designed to project this illusion of absolute unshakable precision. It feels, I don't know, binary.
Yeah, it really does. The architecture is intentionally intimidating. I mean, it operates as this psychological mechanism to make you feel small
Oh, for sure.
and to make the institution feel inevitable. It reinforces this deep-seated assumption that law is just this monolithic structure, like it's something handed down fully formed rather than a messy, evolving human invention.
But the moment you start peeling back the layers, like when you really dive into the historical foundations of the law, the ancient origins of courts, and the evocation of the jury, that pristine marble starts to look a lot more like wet clay.
It really does.
Yeah.
Once you see the historical scaffolding behind modern law, the whole illusion just shatters.
It's completely mind-bending once you realize how it was actually constructed.
Exactly. You begin to understand that the systems we just take for granted today were forged through centuries of violent collisions, bureaucratic accidents, and just desperate compromises.
And that brings us to the mission for today's deep dive. Today, we are unpacking a massive stack of incredibly detailed sources for you.
We've got a lot to cover.
We really do. We are going through legal seminar transcripts, foundational historical documents like the Magna Carta and the Confirmatio Cartarum, and some really rigorous granular analyses of common law versus statutory law.
It's a deep bench of material.
Yeah, and our goal is to extract the mechanics of one core concept, and that is sovereignty. Like, what does it actually mean, legally and historically, to be a sovereign individual?
Right. And how did the blood-soaked battlefields of the ancient world and, the endless paperwork of medieval bureaucrats shape the traffic courts and civil suits we deal with today?
I guarantee that by the time we finish this analysis, you are never going to look at a courtroom, a judge, or even the phrase United States citizen the exact same way again. Okay, let's unpack this.
So the logical place to begin is by stripping the word sovereignty of all its modern political baggage.
Right, because we hear that word all the time on the news.
We do, but when we look at the historical and legal core defined in the sources, sovereignty is simply the power to do everything in a state without accountability to a higher authority.
It's the absolute apex of the hierarchy.
Exactly. In the ancient world, the sovereign was the king, and the defining characteristic of that role is that the king's decree mechanically makes the law.
Just by saying it.
Right. The king doesn't consult a constitutional framework or, legislative body. The utterance itself generates the legal reality.
The sovereign speaks, and the universe just bends to that speech.
Gotcha.
But the sources we're looking at don't just leave sovereignty in the hands of kings, right? They trace this profound philosophical shift that democratizes the concept.
Yes, and they anchor it in something they call the genesis ability.
The genesis ability. I love this concept.
It's a fascinating framework.
Yeah.
So the sources use Genesis 3.22, which is the moment humanity eats from the tree of the knowledge of good and evil. But they don't necessarily use it as theology. They use it as a foundational legal philosophy.
Okay, break that down for us.
Well, the underlying premise is that every single human being possesses an inherent, unalienable capacity to reason about right and wrong.
Which completely upends the top-down model, if you think about it.
Oh, absolutely.
Because if every individual has this genesis ability, you don't need a monarch or a parliament or a 1,000-page printed code book to tell you that, say, burning down your neighbor's barn is a crime.
Right. The community already knows it's a crime because they possess this shared innate moral faculty.
And that shared moral faculty is basically the engine of common law, right?
Yeah, exactly. When we talk about common law in this historical context, we aren't talking about statutes passed by a legislature. The sources define common law strictly as custom and long usage since time immemorial, driven entirely by human reason.
So it's very organic.
Highly organic. It is a bottom-up legal system generated by the people themselves, because the people, equipped with this genesis ability, are recognized as sovereign actors capable of determining justice.
I want to illustrate the mechanical reality of this individual sovereignty using one of my favorite metaphors from our sources. It's the pink shoe law.
Oh yeah, the pink shoe law. That's a great one.
Let's walk through this because it really exposes both the extreme power and the functional limits of operating as your own sovereign.
Walk us through it.
Okay, so suppose I'm standing on my own property, operating entirely in my sovereign capacity. Because my decree makes the law in my domain, I decide I have this visceral hatred for pink shoes.
Just absolutely cannot stand.
Right. So I formally decree a new law. Wearing pink shoes on my land is a crime, punishable by a $1,000 fine.
And under the strict definition we just established, you have the absolute right to make that decree. In your court, on your land, your word is the law.
Exactly. So let's say you walk onto my property wearing neon pink sneakers. I catch you, I point my finger, and I say, you violated my sovereign decree, you owe me $1,000.
Oh,
But here is the mechanism that prevents me from just being a tyrant. The catch is enforcement.
right.
If you laugh at me and refuse to pay and I try to seize that money by force, you have a countermove. You can demand a jury. And in the common law system, the only entity on earth that can limit a sovereign is a jury of other sovereigns.
The jury is the ultimate safety valve here. You take your grievance to 12 random people off the street. You present your case. This person wore pink shoes, violating my sovereign decree.
And those 12 people who are utilizing their own genesis ability, their own shared sense of custom and reason, are going to look at my law and say, that is completely absurd. We nullify your decree. Case dismissed.
Which perfectly demonstrates how common law polices itself. You have the theoretical power to decree whatever bizarre, arbitrary rules you want in your own domain.
Even about footwear.
Right. But the moment you try to project that power onto another sovereign individual, you have to pass the filter of community consensus. If your law violates the shared customs and common sense of the jury, it holds no weight at all.
Now, while I love the elegance of that safety valve, I really have to challenge the practicality of it.
Okay, go for it.
When you describe a system where every single person is walking around as an unaccountable sovereign, inventing their own pink shoe laws, it honestly sounds like a recipe for absolute chaos.
It does sound a bit chaotic.
Right. Like, how does any complex society build roads, engage in interstate commerce, or maintain any semblance of stability if the law is just this patchwork of individual decrees subject to the whims of whatever 12 people happen to be in the jury box that day?
This raises an important question. The fear of that exact chaos is what drove the evolution of the legal system we actually have today. The common law didn't just organically spring up in a vacuum. It was forged in the fires of conflict. To understand how we moved from the theoretical chaos of individual sovereignty to the highly structured courtrooms of the modern era, we really have to look at the collision of three massive, ancient legal philosophies.
We are talking about the great legal mashup of the medieval world. The sources detail how early English law was essentially a violent corporate merger between three distinct cultures, right? The barbarians, the Romans, and the Vikings.
That's a great way to put it. Let's examine the mechanics of each system, starting with the barbarians who swept across Europe and conquered the remnants of the Roman Empire.
The warlords.
Right. Their legal framework was entirely built on the divine right of kings. The mechanism of power was strictly top-down.
So God to king to subjects?
Precisely. Authority flowed directly from God into the king, and the king then distributed limited privileges down to the subjects. The subjects possessed zero inherent rights.
Wow. Zero.
None. Their entire legal existence was just a grant from the sovereign above them.
That's the ultimate manifestation of my decree is the law, just scaled up to a national level.
Exactly. Then you have the Romans, who were, already occupying these territories. They operated on a much more complex middle ground system.
Right, they had written laws and stuff.
They had a senate, they had extensive written codes, but the most crucial mechanism for our discussion is an official they called the praetor.
The praetor. Break that down, because this guy is important.
The praetor was a really fascinating legal innovation. They basically functioned as a buffer between the rigid machinery of the state and the populace.
Like a shock absorber.
Yes. If the strict application of a Roman statute resulted in a massive injustice, the praetor had a degree of equitable authority to intervene, to interpret the law or to issue injunctions.
They were kind of the original middle management of the legal world.
That's exactly what they were. They added a layer of mediation to the raw power of the state.
Which brings us to the third faction, and frankly the most surprising one in a discussion about legal theory. The Vikings.
Yeah, the Vikings.
When most people think of Vikings, they picture longships, raiding monasteries, and absolute brutality. They definitely don't picture sophisticated constitutional frameworks.
No, they don't. Yet their contribution to our modern legal landscape is arguably the most significant of the three.
Really?
Yeah. The Vikings operated on a bottom-up power structure. They held regular assemblies called things, literally spelled Things, where the freemen of the community would gather to resolve disputes and legislate.
And they elected their kings, right?
They literally elected their kings. The
Yeah.
king was not a divine ruler. He was an executive appointed by the people, and he served entirely at their pleasure.
And the most vital mechanism the Vikings brought to the shores of Great Britain was the jury. The concept that a panel of your peers, not a king, not a magistrate, holds the ultimate authority to determine truth and administer justice.
Right, so you have these three entirely incompatible systems thrown into the exact same geographic space.
A total mess.
You have the barbarian obsession with top-down absolute control, the Roman reliance on bureaucratic mediation, and the Viking tradition of bottom-up, community-driven justice.
And the way these systems merged is incredible because it wasn't some high-minded philosophical compromise. It was just a logistical necessity.
Completely logistical.
Because when the barbarians conquered Rome, and later when Viking influence swept through Great Britain, the warlords had a very practical problem. They had enough swords to conquer a territory, but they completely lacked the administrative infrastructure to actually govern it.
Right, you can burn down a city, but you still need someone who knows how to collect the taxes, file the grain reports, and just organize the logistics of an empire.
And they had no choice but to rely on the surviving local administrators.
Exactly. The barbarian kings found themselves entirely dependent on the Roman clerks and bureaucrats who already knew how to run the machinery of government.
I love this dynamic. I like to compare it to a chaotic corporate takeover.
Well, that's a good analogy.
Just imagine this volatile, visionary CEO buying out an old, established company. The new CEO, who is basically the barbarian king, shouts a brutal top-down order from the boardroom. Execute anyone who is late on their taxes.
Right, very barbarian.
But the person who actually has to write the memo, translate it into legalese, and distribute it to the regional offices is a Roman middle manager who is accustomed to praetors, due process, and Senate rules.
So the Roman clerk takes this absolute decree and begins to massage it. They filter it through their own legal traditions.
So it doesn't say execute everyone anymore.
No, the decree that goes out to the provinces says something like, the crown mandates strict penalties for tax evasion, subject to review by the local magistrate.
Bureaucratic dilution.
Exactly. The raw, top-down power of the barbarian king is continuously diluted and altered by the bureaucratic machinery he relies on.
Here's where it gets really interesting. This massive administrative friction, the barbarian kings trying to enforce divine right, while the local populations and Viking-influenced communities demand their bottom-up jury rights, created a massive pressure cooker.
A huge one.
And that pressure cooker eventually exploded, leading to the creation of the dual court system we still grapple with today.
And the explosion you're referring to happened in 1215 under the reign of King John of England.
Good old King John.
The historical context here is really vital. King John was aggressively fighting wars in France, and those wars were draining the treasury. So, to finance his campaigns, he leaned heavily into the barbarian model of absolute top-down power.
They're just squeezing everyone.
Yeah, he was arbitrarily conscripting the nobility, seizing estates, and taxing the barons to the point of absolute ruin.
He pushed that divine right mechanism way further than the system could handle. And the barons, who we have to remember were not just wealthy landowners, but warlords with their own private armies, they finally snapped.
They had enough.
They mobilized their forces, marched on the king, and trapped him in a meadow at Runnymede. And with their swords drawn, they forced him to sign a treaty.
The Magna Carta. The Great Charter.
Yeah.
Now, the sources emphasize a detail that often gets glossed over in standard history classes. King John never intended to honor a single word of that document.
Wait, really?
Not a single word. He signed it under duress simply to survive the day. The moment he was safe, he petitioned the Pope, who immediately annulled the charter, declaring it illegal and unjust.
Okay, so if the Magna Carta was instantly annulled and ignored by the guy who signed it, why does every legal scholar point to it as the bedrock of Western law? How does a voided document change the world?
Well, the physical document was annulled, sure, but the concept it represented had been permanently legitimized in the minds of the people. It established the written precedent that the king was not above the law.
The idea was out there.
Exactly. And we see the mechanical realization of this several decades later, in 1297, under a new monarch, King Edward I. The nobility approached Edward and demanded that the principles of the Magna Carta be formally reinstated.
And Edward, perhaps realizing that ignoring armed barons was bad for his health, agrees. He issues a document called the Confirmatio Cartarum.
The confirmation of the charters. This was the true turning point. In this document, King Edward explicitly instructed his entire royal bureaucracy, his justices, sheriffs, and mayors, that if any subject demanded it, the Magna Carta was to be recognized and enforced as the common law of the land.
So the king basically formally subordinated his own courts to the fixed rules of the people.
He did, but this created a massive structural schism in the legal system. Suddenly, there were two distinct houses of law operating side by side.
Okay, two houses.
On one track, you had the common law. This is the realm of the people, governed by fixed customs, the generalizability of the jury, and the protections outlined in the Magna Carta.
Very rigid.
Very rigid. And on the parallel track, you had what became known as equity law, or chancery. As you said, the common law was rigid. It operated on strict writs and historical precedents. If a citizen had a novel problem that the fixed rules of common law couldn't solve, or if the strict application of the law resulted in an obvious injustice, they could bypass the courts and petition the king directly, begging for his grace.
But the king is running an empire. He doesn't have time to hear every dispute over a property line, right?
No, he definitely doesn't. So he delegates this power to his closest advisor, the chancellor. And this is where we see the ghost of the Roman praetor reappear.
Ah, the middle manager returns.
Exactly. In the equity courts, the chancellor wasn't bound by juries or fixed precedents. He could literally invent new rules on the spot, suspend existing laws, or issue injunctions, all under the guise of acting according to the king's conscience and ensuring fairness.
What's fascinating here is that the Chancellor's Court of Equity became a really powerful tool for the monarchy.
A very powerful tool.
Because while the common law courts belonged to the people and the juries, the equity courts belonged to the king. They were flexible, they were arbitrary, and they were designed to protect the sovereign's interests when the rigid rules of the people became inconvenient.
That tension between the fixed, jury-driven common law and the flexible, judge-driven equity law is the defining feature of our legal architecture.
To make this tangible, I want to use a modern corporate analogy.
Sure.
Think of the common law as the strict, written code of conduct in a massive company handbook. If an employee breaks a rule, there is a set procedure, a tribunal, and fixed consequences. It's rigid but predictable.
Okay.
Equity law, on the other hand, is the HR department.
Oh, that's brilliant.
If a high-level executive gets into trouble, HR can suddenly bend the policies, invent a new performance improvement plan, and handle the situation quietly to protect the company's reputation. Equity is the flexible power of the executive disguised as fairness.
That is a perfect way to look at it. But to truly grasp how these systems operated in practice, we have to look at the physical origins of the courtroom itself.
Yeah.
Like, why did kings who believed they had divine authority even bother building courts in the first place?
The sources provide an incredible narrative to explain this, which we can call the story of the king and the orange thief. It perfectly illustrates the hidden mechanics of medieval power. Let's set the stage.
Let's do it.
It's the 13th century. The king is standing on the balcony of his stone keep, looking out over his domain. Down in the royal gardens, he spots a local knave climbing his favorite prized orange tree and stuffing fruit into his tunic.
A blatant theft of royal property. And a direct violation of the sovereign's law.
Exactly. Now, the king is furious. Under the theory of divine right, his immediate impulse is to send his guards to grab the thief, drag him to the deepest dungeon, and just leave him there to rot. No trial, no jury, no paperwork. The king's will is absolute, so his vengeance should be absolute.
And he possesses the theoretical legal authority to do precisely that.
But he hesitates. Because the king is acutely aware of a very practical biological limitation on his absolute power. The sources refer to this as the arsenic factor.
The arsenic factor. It is the ultimate check and balance in a pre-democratic society.
Let's trace the mechanics of this arsenic factor. Suppose the king indulges his wrath and throws the knave straight into the dungeon. A week later, it's visiting day. The knave's brother comes down to the cells. The knave clings to the bars and whoops, claiming, "I am innocent. I was merely walking past the gardens." The king is a paranoid tyrant, and this is completely unjust.
And the brother, naturally, is going to believe his own family over some distant monarch.
Right. So the brother leaves the dungeon furious. He goes to the local tavern and starts telling everyone who will listen. The king is a monster. He is arbitrarily throwing innocent people in holes.
And the story spreads.
The community becomes agitated. They start viewing the king not as a divine ruler, but as a dangerous, unpredictable threat to their own safety. And the king, sitting up in his castle, knows that he is ultimately just a mortal man. He eats food prepared by servants. He drinks wine poured by courtiers. If a critical mass of his subjects decide that he is an arbitrary tyrant, someone is eventually going to slip a lethal dose of arsenic into his goblet.
What's fascinating here is that a king can decree whatever he wants, but he cannot legislate away his vulnerability to an angry mob or a poisoned cup.
So the king realizes that raw, unchecked power is practically a death sentence. And to neutralize the arsenic factor, he invents a theatrical production.
He creates the proceeding we now recognize as a court.
Instead of tossing the knave straight into the dark, the king brings him into a grand, brightly lit hall. He invites the knave's brother and the entire village to watch from the gallery. The king has a prosecutor formally read the charges. He allows the knave to speak. He presents witnesses who saw the theft. He orchestrates this massive, formal spectacle of justice.
And the purpose of the spectacle is not to discover the truth. The king already knows the truth. He saw the theft with his own eyes.
The purpose is public relations. The trial is designed entirely to convince the knave's brother and the community in the gallery that the knave actually committed the crime. So when the gavel finally falls and the knave is dragged off to the dungeon, the crowd nods along and says, "Well, we saw the evidence. He had his chance to speak. It was a fair process. He deserves the dungeon."
By creating the illusion of a fair contest, the king manages public opinion. He executes his original will, punishing the thief, but he does so in a way that prevents the community from reaching for the arsenic. The court was engineered as a mechanism to legitimize the sovereign's actions in the eyes of the public.
This is a staggering revelation, honestly. The origins of due process, the foundations of the public trial, weren't born out of some noble desire to protect the rights of the accused.
Not at all.
They were invented as a PR campaign to protect the neck of the king. The court was a stage play designed to launder absolute power into acceptable justice.
When you understand that historical reality, you realize that our modern definition of a court is fundamentally flawed. People look at the marble building and assume the architecture is the court. Right.
But the strict historical legal definition found in the foundational texts is completely unmoored from physical space. A court is formally defined as the person and the suit of the sovereign.
The person and the suit of the sovereign. We really need to deconstruct this phrase meticulously because it changes the very nature of what a legal proceeding is.
Our sources break down the architecture of a true court of record into 4 distinct entities. In the traditional common law system, if any one of these 4 components is missing, the proceeding is not legally a court of record.
Okay, let's analyze these entities one by one. The first entity is the sovereign plaintiff.
Right.
This is the person who initiates the action. Without a sovereign claiming a grievance, the court cannot exist. The plaintiff's inherent authority is the spark that brings the court into being.
The second entity is the defendant, or the respondent. And this is where the sources highlight a mechanical difference between civil common law and the statutory criminal law we see on television.
This blew my mind. It's wild. In a common law dispute between 2 individuals, the defendant is technically presumed guilty until they prove their innocence, or until they default.
This sounds entirely backwards to modern ears. We are constantly drilled with the phrase innocent until proven guilty. Why would a system built on individual rights presume guilt?
Well, the presumption of innocence is a vital protection when the massive machinery of the government is prosecuting a citizen in a statutory criminal court.
Because of the power imbalance.
Exactly. But in a common law civil suit, you have one sovereign accusing another sovereign. The plaintiff has already sworn under penalty of perjury that they have been wronged. Therefore, the burden shifts immediately to the defendant to answer the charge.
Wow, okay.
If you accuse me of burning down your barn and I simply ignore the summons and fail to show up, I lose by default. My silence is taken as an admission of guilt because I failed to answer the claim of a fellow sovereign.
That actually tracks logically. If someone serves me with a lawsuit for destroying their property, I can't just throw the paper in the trash and assume I'm safe because I'm innocent until proven guilty. I have to actively defend myself.
Right.
Okay, moving to the third entity, the jury. But in a court of record, the jury isn't just an advisory panel giving a recommendation to the judge.
No, in a true court of record, the jury is the ultimate tribunal. They hold the absolute power to decide the facts of the case, and historically they possess the power to judge the validity of the law itself. They are the community consensus acting as a counterbalance to the sovereign plaintiff.
And the fourth entity is the court itself. But as we established, the court isn't the physical room.
The court is a legal fiction. It is an ethereal space, a metaphysical proceeding created solely by the convergence of the sovereign plaintiff, the defendant, and the jury.
This concept of the court as a non-physical entity ties perfectly into a fascinating linguistic evolution highlighted in the sources. We use the word lawsuit or suit every day. I'm filing a suit. But where does that term actually originate?
It's a great story.
The history reveals the mechanics of how these metaphysical courts actually kept records before the invention of the filing cabinet.
We have to return to the medieval king. In this era, kings were often brilliant military tacticians, but they were largely illiterate. They could not read or write.
So if the king issues a decree on Tuesday, how does he remember the specifics of that decree 3 years later when a similar dispute arises?
He relies on the biological hard drives of the people around him. He relies on human memory.
His entourage.
Yes. The king was constantly surrounded by a suite of courtiers spelled S-U-I-T-E. This was a retinue of nobles, advisors, and knights who followed him everywhere. When the king held court and made a ruling, the collective memories of his suite became the official record of the court.
That's incredible.
Years later, he could turn to his advisors and ask, "What was our ruling regarding the miller's taxes?" And the suite would recite the precedent.
So over centuries, as society evolved, literacy spread, and the printing press was invented, those human courtiers were replaced by parchment, and eventually by 8.5 by 11 sheets of paper filed with a county clerk.
Yep.
The physical suite of people morphed linguistically into the suit of paperwork. So today, when you file a lawsuit, you are metaphorically assembling your courtiers around your throne. Your stack of affidavits and complaints serves as the record of your sovereign decree.
Which leads us to a critical question about the modern courtroom setup. If the plaintiff is the sovereign creating the court and the jury is the ultimate tribunal deciding the outcome, what exactly is the judge doing up there on the mahogany bench?
This is where the architecture of the courtroom lies to us again. The bench is placed higher than everyone else to project authority, but the sources use a powerful metaphor to describe the judge's actual historical role in a court of record. They describe the judge as a mirror.
A mirror. The magistrate is merely a reflective surface. Their sole function is to reflect the sovereign authority of the plaintiff and to ensure that the procedural rules of the trial, the theatrical elements of the stage play, are properly executed.
They just keep running.
Right. The magistrate is independent of the tribunal. They do not possess the power to make the final determination of fact or law.
If a judge attempts to dictate the outcome to the jury, or if they try to alter the sovereign plaintiff's claim to fit their own agenda, they cease to be a mirror. They become a distorted lens. They are broken. In a true common law court of record, the judge is a ministerial administrator, not a king.
This completely inverts the power dynamic we're accustomed to. And this inversion extends to the historical reality of the jury itself. We constantly hear the phrase, a jury of one's peers.
All the time.
Today, we interpret peers to mean 12 random citizens who happen to live in our zip code. But the medieval origins of this concept are far more intense and militaristic.
Yeah, we have to remember that in medieval England, a peer referred to the peerage, the nobility. And a duke or a baron wasn't just a wealthy guy with a fancy title and a nice hat. They were warlords.
Armed warlords.
They commanded massive estates, and crucially, they controlled their own private armies.
The sources introduced the concept of the 13 armies to explain the mechanical power of the early jury. If a powerful baron wanted to enforce a legal ruling against a rival baron, he couldn't just ask nicely. The rival would just ignore him.
Right.
He needed an overwhelming threat of violence to back up the legal decree.
So the plaintiff baron would gather 12 other nobles to sit in judgment, 12 warlords, each bringing the implicit threat of their own military force, plus the plaintiff's army. That equals 13 armies aligned against the single defendant.
It was an overwhelming display of martial power masked as a legal proceeding.
The jury wasn't just a panel of impartial observers, they were the physical embodiment of the community's capacity for violence.
Exactly. When the jury of peers handed down a verdict, it was backed by a 13-to-1 military advantage, making any resistance by the defendant completely futile.
The legal authority of the jury was derived directly from their capacity to violently enforce the consensus. So what does this all mean? We've navigated through the Genesis ability, the bureaucratic dilution of barbarian kings, the arsenic factor, and the militarized origins of the jury. The crucial question is, how does this ancient, blood-soaked history connect to you, the listener, walking your dog or sitting in traffic right now?
The connection occurs at the founding of the United States. In 1776, the American colonies did something unprecedented. They fired their sovereign. They severed the top-down mechanism of the British crown.
But according to the legal philosophy we've been tracking, when you remove the king, the sovereignty itself doesn't just evaporate into the ether. It has to go somewhere.
It devolves.
It transfers directly into the hands of the people who dismantled the old system and created the new one.
Which brings us to the profound and often misunderstood dichotomy at the heart of modern American law: the stark division between the people and citizens.
This is the great divide. The legal theory we are about to unpack explains exactly why, despite allegedly holding this devolved sovereignty, we usually feel like helpless subjects when dealing with the modern legal system.
We really do.
Let's start with the creators. Look at the preamble to the Constitution. It doesn't say "we, the government." It says, "We, the people of the United States, do ordain and establish this Constitution."
The language is hyper-precise. The people are the architects. They are the creators of the government. And in legal mechanics, the creator is always sovereign over the creation.
The maker is above the thing made.
Yes, the people, acting collectively and individually as joint tenants in that sovereign power, are fundamentally unaccountable to the government they manufactured, except in the specific areas where they explicitly delegated authority.
So if the people are the sovereign creators, why doesn't my daily life reflect that? When I get called for jury duty, or when I'm standing in line at the DMV, I definitely do not feel like a sovereign creator dictating terms to my administrative creation. I feel like a subordinate jumping through bureaucratic hoops.
You feel that way because the system is operating exactly as it was redesigned to operate after the Civil War. The sources argue that this feeling of subordination is rooted in the specific legal definition of a citizen, a status that was formalized by the 14th Amendment.
We need to dissect this because in everyday conversation, we use the words person, people, and citizen completely interchangeably.
In colloquial English, sure, they are synonyms, but in the strict mechanics of the law, they are entirely distinct jurisdictions. Prior to the 14th Amendment, the Constitution did not contain a clear, overarching definition of a citizen of the United States.
Which is wild to think about.
Right, but the 14th Amendment provided one. It reads, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside."
The entire trap is hidden in one clause, and subject to the jurisdiction thereof.
That is the operational phrase. A sovereign, by the very definition we established at the beginning of this deep dive, is not subject to a higher authority.
Right.
But a citizen, under the 14th Amendment definition, explicitly is subject to the jurisdiction of the government. The sources posit that the 14th Amendment essentially created a statutory class of individuals who are legally defined as subjects of the corporate state.
The implications of this are staggering. It means that the people operate under common law and possess inherent natural rights by virtue of their genesis ability. But citizens operate under statutory law, and what do citizens possess instead of natural rights?
Citizens possess civil rights, and the sources make a crucial, provocative distinction here. They argue that civil rights are not actually rights in the philosophical sense. They are privileges.
Privileges.
Yes. They are franchises granted by the government to its subjects. And the mechanical reality of a privilege is that whatever the government grants, the government has the authority to regulate, license, tax, condition, or theoretically revoke.
Wow. So a natural right is your inherent ability to travel freely. A civil privilege is a driver's license that can be suspended if you don't pay a fine.
Exactly.
To illustrate how this linguistic trap plays out in an actual courtroom, the sources provide a wild anecdote from San Diego regarding the concept of a jury of peers.
It is a perfect demonstration of how these two distinct houses of law interact. In this San Diego case, a defendant was on trial and actively demanded his historical right to a jury of his peers.
And based on our historical analysis, a peer to a sovereign individual must be another sovereign individual, a fellow member of the people.
Exactly. So during the jury selection process, the voir dire, the judge, and the attorneys are questioning the jury pool. The defendant's counsel asks the prospective jurors a highly specific legal question. Are you one of the people of the state of California, or are you a citizen of the United States?
Because we are conditioned from birth to view the word citizen as the highest possible civic honor, I bet every single person in that jury pool confidently raises their hand and declares, I am a proud citizen of the United States.
They absolutely did.
Uh,
But by claiming that specific legal status, they were unknowingly admitting that they were statutory subjects of the government, subject to its jurisdiction.
oh,
They
man.
were legally declaring that they were not sovereigns. Therefore, under strict historical definitions, they were not the peers of a sovereign individual. According to the sources, because not a single person would claim the status of the people, the court was unable to seat a valid jury of peers, and the prosecution collapsed.
It sounds like a Jedi mind trick. It sounds like someone found a cheat code in the matrix of the legal system.
It really does.
But I have to push back incredibly hard on the real-world utility of this information. It is intellectually fascinating to debate the 14th Amendment and common law sovereignty in a legal seminar. But in the physical world, if I am driving down the highway at 80 miles an hour and a police officer pulls me over and I roll down my window and declare, Officer, I am not a citizen subject to your statutory jurisdiction. I am a sovereign member of the people operating under common law. That is not going to end with a philosophical debate.
No, it is not.
That is going to end with my window getting shattered, me getting tased, and me spending the weekend in a concrete cell.
Your pushback is entirely valid, and the source is explicitly warned about this exact danger. The internet is full of videos showing people attempting to use sovereign legal theories as magic spells to get out of traffic tickets, and it almost always ends in disaster.
Yeah, we've all seen those videos.
Asserting sovereignty is not a get-out-of-jail-free card. If we connect this to the bigger picture, the sources emphasize that you cannot selectively assert sovereignty while simultaneously swimming in the benefits of statutory citizenship. You have to understand the mechanics of contracts.
You are talking about the difference between the House of Common Law and the House of Equity Law.
Yes. The moment you enter into a contract with the government, you are stepping out of the absolute freedom of the common law and entering the regulated domain of equity and statutes. The sources point to the Hickorilla case to explain the mechanics of how this works.
Let's break down the Hickorilla case. What happened? And how does it explain the limits of sovereignty?
The case involved the Hickorilla Apache Nation, a recognized sovereign tribe. The tribe entered into a standard commercial contract for mining operations on their land. A dispute arose, and the opposing party argued that because the Hickorilla Nation had engaged in ordinary commercial activity, basically acting like a regular business corporation, they had implicitly waived their sovereign immunity.
The argument is, if you play in the commercial sandbox, you have to play by the commercial rules.
But the Supreme Court ruled differently. They stated that entering into a specific commercial contract does not extinguish your underlying sovereignty. You merely yield your jurisdiction for the specific terms and purposes of that contract.
So how does that apply to the listener who just got pulled over?
Think about a driver's license. When you apply for a driver's license, you are entering into a contract with the state. You are essentially saying, in exchange for the civil privilege of operating a motor vehicle on the public highways you maintain, I agree to be bound by your statutory motor vehicle codes.
Oh, okay, I see.
For the specific purpose of driving, you have voluntarily adopted the status of a subject citizen.
So when the officer pulls you over, you can't suddenly claim, I'm a sovereign, your rules don't apply, because you literally signed a piece of paper agreeing that the rules do apply while you were behind the wheel.
Exactly. You cannot hold the government to the strict rules of common law while you are operating under an equity contract. However, the Hickorilla ruling means that holding a driver's license or a social security number does not permanently erase your status as one of the people.
That's a crucial distinction.
Right. You can be a statutory citizen for the purpose of driving and a sovereign for other aspects of your life. But the burden is entirely on you to know which legal hat you are wearing at any given moment and to understand the jurisdictional rules of the house you are standing in.
It requires a level of extreme, almost exhausting personal responsibility.
It really does.
The system isn't going to hold your hand and remind you of your sovereign rights. In fact, the system relies on you defaulting to the easier managed status of a subject citizen. But the most surprising thing is that the modern government actually admits this reality in its own printed codes. The sources point to the Brown Act in California.
The Ralph M. Brown Act is a standard piece of legislation governing public meetings and transparency. But the legislative declaration at the very beginning contains a stunning admission.
What does it say?
It states, "The people of this state do not yield their sovereignty to the agencies which serve them."
I want to repeat that because it is hiding in plain sight. Do not yield their sovereignty. The state legislature explicitly acknowledges in writing that the ultimate sovereign power remains with the people and that the government agencies are merely servants.
The legal architecture still recognizes the creator-creation dynamic. The government knows it is the agent, and the people are the principals. But if you walk into a courtroom acting like a subject, relying on a public defender, and citing statutory privileges instead of demanding a common law court of record, the system will treat you as a subject.
Because you act like one.
Exactly. Sovereignty is not something that is given to you. It is a posture you must actively maintain through deep knowledge of the legal machinery.
This entire analysis completely reframes the relationship between the individual and the state. It moves you from being a passive consumer of justice, hoping the system treats you fairly, to realizing that you are historically designed to be the active architect of the law.
It is a daunting realization. Operating in the common law requires you to rely on your own genesis ability, to stand before a jury of your peers, and to take absolute responsibility for your decrees.
Yeah.
It is much easier to just accept the statutory matrix, pay the fine, and let the bureaucracy manage your life. That is why the statutory system has become the dominant reality for most people.
We have covered a massive amount of historical and legal territory today. Let's take a breath and retrace the path we just walked for you, the listener. We started with the genesis ability, the philosophical bedrock that every individual possesses an inherent capacity to reason right from wrong, which forms a foundation of the common law.
And then we examined how that bottom-up philosophy, championed by Viking assemblies, violently collided with the top-down divine right of barbarian kings.
And how Roman bureaucrats accidentally forged a hybrid system by diluting those absolute decrees.
Right. Then we watched the barons force King John to sign the Magna Carta at sword point, and saw how King Edward's Confirmatio Cartarum formally split the legal world into two houses: the rigid, jury-driven common law of the people and the flexible, chancellor-driven equity law of the king.
We decoded the arsenic factor, realizing that the public trial was invented as a theatrical PR mechanism to prevent kings from being poisoned by angry mobs.
A literal stage play.
Exactly. This redefined our understanding of a true court of record as an ethereal proceeding consisting of a sovereign plaintiff, a defendant, a jury backed by the martial threat of 13 armies, and a judge acting merely as a reflective mirror.
And finally, we unpacked the 14th Amendment and the great divide between the sovereign people who created the government and possess natural rights, and the statutory citizens who are subject to its jurisdiction and possess only revocable civil privileges.
The overarching lesson from these sources is that the language of the law is hyper-precise. Everyday words contain centuries of hidden legal mechanics. Whether an institution classifies you as a client versus a customer, or whether a court addresses you as a person versus a citizen, these are not casual synonyms.
They absolutely are not. They are distinct jurisdictional statuses that dictate the balance of power.
Understanding that history is the only way to effectively navigate the system. Which brings me to the final thought. I want to leave you with something to mull over long after this deep dive is finished. We spent a lot of time establishing that the common law is defined entirely by custom and usage since time immemorial. It is completely reliant on a jury's shared sense of right and wrong.
It requires a unified genesis ability.
Yes, it requires a profound community consensus. But what happens to the common law in our modern, hyper-connected, deeply polarized society? We are living in an era where our shared customs, our shared morals, and our basic consensus on what constitutes reality are fracturing at unprecedented speeds.
That's very true.
If you pull 12 random people off the street today, they might not agree on the most fundamental definitions of right and wrong. If a jury can no longer reach a consensus, does the common law collapse? Are we organically attempting to forge new common law right now through the chaotic friction of modern culture? Or are we fracturing so severely that we are willingly surrendering our sovereign power entirely to rigid, top-down, barbarian-style statutes just to maintain order?
That is the existential test of any free society. When the internal moral compass of the people shatters, the external coercive control of the state inevitably expands to fill the void.
Think back to that polished marble courtroom we described at the very beginning, that comforting illusion of binary perfection. Maybe the cracks forming in that marble aren't coming from the violent history we forgot, but from the shared consensus we are losing right now. Thank you for joining us on this deep dive. Keep questioning the fine print of history, keep exercising your Genesis ability, and we will see you next time.